Today we are talking with our agency partner, Diana Buscetto from SAVA Insurance Group, on the benefits of employers' practice liability insurance, otherwise known as EPLI. This is the first part of a three-part series. Diana, I have a few questions that have been commonly asked from our clients, and I'm hoping that you can share some of your insight and knowledge. First question actually is, why would an employer need EPLI insurance?
So we get that question a lot, obviously. So employment practices liability, also known as EPLI, like you said, it actually gives the business protection if an employee sues them for wrongful termination, discrimination, harassment. There's also coverages in there that include FLSA, which is Fair Labor Standard Acts coverage. So if they're sued for any wage or hourly dispute, it gives coverage for that as well. This policy gives coverage for settlement and defense costs. So at the end of the day, you can terminate an employee and maybe you did everything the right way. You documented everything you should, all your T's are crossed, all your I's are dotted. And if they leave as a disgruntled employee, they can go and actually throw anything at you, see if it sticks against the wall, and you have to defend yourself. So maybe there's no settlement, but if you don't have this policy in place, you're paying out of pocket to defend yourself against the allegation.
That's helpful for employers, obviously, and there's all different types of employees, full-time, part-time. There's volunteers. A lot of our nonprofit clients have a lot of volunteer employees. Does it protect them as well?
It does. So when I usually say employees, there's a broad range of it. So it will cover full-time employees, part-time employees, seasonal employees, temporary employees, independent contractors, and also volunteers. So all types of businesses obviously have all of those different exposures, but in the nonprofit world, the independent contractors and the volunteers are huge, because they do whatever they can to try to protect themselves with different policies and procedures in place. But at the end of the day, if one of their employees or one of their volunteers goes and discriminates against somebody or harasses them in some way, the organization is the one who they're going to come after. And because that volunteer or that employee or that contractor was acting on behalf of the business or the nonprofit, this policy is going to defend them same exact way, as long as it's in operations of their business exposure. Obviously, it's not going to protect, me if I go on a weekend and it's nothing to do as far as the business or the nonprofit goes. But if it's in the realm of their operations or their normal duties, this policy is going to respond, again, defense costs and settlement costs.
You and I were talking a while back about some of the coverages that are included in the EPLI insurance, and you had given me a really good example of something that I didn't think could actually happen. Where it was really a harassment scenario, and it was so obscure you would never in a million years think that this could be a situation, but it actually was. Do you think you could share that story that you shared with me?
Yeah, absolutely. So, people just think the employment practices liability is just that only, but there's different components to it. So you have obviously the defense and the settlement costs. There's also what's called third-party coverage. So the third-party coverage would be, for example, I'm going to use you, Stephanie. Somebody comes to your business, whether it's a mailman, a FedEx, what have you. One of your employees makes a comment to them, joking around, maybe, they think they're being nice and funny, and it might have hit a nerve on that person who they felt that was harassing in some way. He goes and files suit because that employee was working with you in your operations. Right. That FedEx, mailman, whoever that third party is, can actually come back and sue you because of that employee's remark. And sometimes, people don't intentionally try to make derogatory remarks. They think it's funny, but different people have different boundaries as far as what they think is acceptable and not acceptable. So in that situation, that employment practices liability gives coverage for third party. So that would be a scenario of a third party claim. And it also gives coverage for Fair Labor Standard Acts, which is FLSA. So if any of your employees say you didn't pay them the correct overtime, or they were supposed to get this bonus or what have you, and they go and they're like, you're not taking care of me the way you should. These policies would cover that up to $100,000. So our agency personally, we've probably had about 6 or 7 of those type of claims happen. So it does happen. And for a company to have to pay $50,000 or $60,000, if you don't have that policy in place, that's a big hit, no matter what size business you are.
It sure is, both for a profit company, but also for a nonprofit company.
Absolutely.
Nonprofits are usually looking to keep every dollar they can in-house so that they can spend it on the organization that they're trying to support. So this is really great information, and I appreciate you talking with me and answering some of these questions. Like I said, they're very common questions that our clients have asked, and we're able to give them some great knowledge. So we'll conclude this topic today. I think our next series is going to be specifically talking about directors and officers insurance. Yep. So we're looking forward to talking with you on that. Thank you very much for the information.
Thank you for having me.